Greetings, everyone. My name is James Burkhart, and this is the Political Divide. So, today's discussion is gonna be. I've got a couple things I've wanted to talk about. I want to talk about. I don't know if I did one on calling out. If I did that one. I wanted to talk about the difference between flip-flopping and changing your mind. I don't think I ever posted that one that I did earlier about that. I wanted to talk about uh, well, there's so many things. It's one of the worst things about this case. I wanted to talk about um, the Mueller thing again and expansive problems. I wanted to talk about uh, potential crimes related to the election that have nothing to do with Russia, uh, um, uh, and a lot of other, and why Rudy Giuliani is the most incompetent lawyer I've ever seen. Um, but not going to talk about any of that. No Trump talk today. No theory talk today. I'm gonna, no general argumentation talk today. I know I'm gonna talk today about Brock Turner. You guys may have remembered a couple years back, year or two back, he made big headlines. He was caught, where he was found by two people, by two other males, seemingly going at a female in a state of undress, behind a dumpster or something, um, in public. And so there were a lot of, uh, eventually he was convicted of rape and was given a lenient sentence. And I'm not going to go deep into that lenient sentence, only to say that while ridiculous, for those who believe that rape is in fact even worse than murder and should get the harshest possible sentences, uh, it is entirely consistent with this judge's sentencing patterns, and everyone will try to draw connections to other criminals, domestic abuse, or like other crimes we consider to be targeted primarily at women, like a domestic abuse, and say that this guy was. And then there was of course, the narrative of Brock Turner being a rich white male, and so this lenient sentence seemed to be some kind of, sexist, racist, judicial ruling, and that's not what it was. This judge did it for everybody, including minority, POC, um, um, lower class, drug minor drug offenders. Everyone who came through his courtroom received low sentences. If there were mandatory minimums, he would give minimum sentences. He was doing one of the things we've been saying the judiciary needs to do, which is to stop throwing the book at people and start being lenient with their sentencing in an effort to make sure that we don't have uh, jails filled with recidivists who can't get out of the cycle of incarceration. And one of the things you do there is by providing lenient sentencing for first-time offenders. Whether it was appropriate in Brock Turner's case, I can't say, but I will say it was contextually. I will say not contextually, but it was entirely in line with the known sentencing pattern of this judge. known long before the Brock Turner case, and the narrative that's been built, especially with the lawyer's discussions of what happened over the course of the case. There's this account where she talks about how she saw the person before him get a lenient sentence. She's like, oh my god, this guy's going to get a lenient sentence. And it's like, lawyers normally research the judges in their cases. That way they know the foibles of these judges. They have to, because they need to know the judge's specific courtroom etiquette rules, specific rules of procedure to this judge. So she should have known this judge's proclivity for lenient sentencing. So I highly question the narrative that it was somewhat shocking that there was lenient sentencing in this case. But but that's not what I want to talk about today. I want to talk today about the appeal that got heard recently, probably yesterday, because the article started coming out about Brock Turner's appeal. He is trying to appeal the ruling, and I don't understand what he's trying to appeal about it, but I'll get into that when I start talking about the appeal. So please note that appeals generally are trying to judge matters of law. Generally, that there was some sort of miscarriage of justice in the trial, and on appeal, you are trying to resolve that. There are a couple reasons for this. One is because you believe the law was wrongly applied, or perhaps you believe precedent was incorrectly applied, or that precedent has unfairly locked your case in. You'd probably need to go up to a higher court to get the precedent challenged. So these are the two biggest ones. You can also get ones like your rights not being upheld, or jury instructions or such. Some instruction generally that prejudiced the person who lost the case. Prejudiced the case against that person. So the everything I can find on it says that what they're basically trying to state is that what he did wasn't rape, that what he was trying to do was he was not looking for penetrative sex, merely, as it's referred to, outer course, which is to say to rub the male genitalia on a female on a female without penetrative sex. Does not necessarily even need skin-to-skin contact, but I believe the record, given the record of the conviction, it will have been established that skin-to-skin contact was likely, given it was believed previously that he was actually having penetrative sex. So trying to claim that he did not have skin-to-skin contact is probably not going to fly. One of the things about an appeals court is they very rarely rule on issues of fact. In a criminal case, very rarely will a issue of fact be overturned by an appellate court. That is the providence of the jury. And in the end, the jury is supposed to be, hitting a very high standard intentionally, the beyond a reasonable doubt standard. Therefore, without that standard, because they've hit that standard, they believe there is sufficient evidence to prove that this happened. Now, you can talk a lot about potential. There can be talk about the fact that the jury process, in such cases, it can be prejudiced, um, and biased against the defendant, and we do our best to eliminate that bias in jury selection. It's why a jury selection for a case such as Brock Turner's probably took days, to find a jury that the defense believes is sufficiently lacks bias to provide a fair trial. Um, uh, Unfortunately, with a case like this, there isn't a good much else we can do about that fact. Um, the evidence is pretty good, so uh, but so he is claiming, the lawyer is claiming that he was going for outer course and that there wasn't an intent and that there wasn't any actual rape that occurred, and therefore she shouldn't have to register as a sex offender. And I just want to highlight this point for a moment. Unfortunately, that admission already puts him two ways on the sex offender list. I guess they're trying to avoid getting on the rapist list, um, or trying to, like, I don't understand what the end game for this appeal is supposed to be, because they're already admitting to sexual assault, um, both by stripping the woman and because she was found in a state of undress, remember, um, and exposing himself and rubbing on her. The factual record, as established by the jury, um, was enough to establish that the acts were not consensual, so he can't be claiming that. Um, so I'm not sure where this helps him. And then additionally, he's got his stuff out. He's admitting to having his stuff out in public. That's indecent exposure. That's also getting you on the sex registry. And I realize there are levels of the sex offender registry, but honestly, he's hit several of them. Um, I can't imagine that there is any situation at this point where that's going to be. Uh, I can't imagine at this point, um, that there is any situation in which. Sorry. I can't imagine at this point that there is any situation in which Brock Turner, uh, even if this appeal succeeds and the charges get reduced, that it's really going to help him. Oh, he only needs to be on the sex offender registry for 30 years for his for his counts of sexual assault and indecent exposure. Does he really want to go back and get those on it, and get multiple, instead of a single count of rape, get multiple counts of sexual assault and indecent exposure, and only be on the sex offender registry for 30 years? I mean, all they're doing at this point is Streisanding this case and keeping it in the public eye. That's going to make it so much easier 30 years from now that someone's going to find records of this case and go, yeah, it appears you were convicted of rape and it was reduced to sexual assault because apparently you only intended to rub yourself against her buttocks. I'm sorry, I don't seem to find the distinction. I'm not gonna like, what is the I guess they're betting that the whole Me Too and women's equality movements are just going to die. and it'll be good old boy time again. Uh, and so no one will care. I don't see where this appeal makes Brock Turner look any better, especially given that apparently, like at his trial, he was trying to claim it was consensual and never. So here's the big problem. So I've gone through the like, if this worked, what would be a problem? But here's the problem with it working. A lot of the times, details like this, this is actually a factual detail is trying to be brought up at appeal. Um, and that's a problem because uh, it is not a, like, this is something that should had this been, if this was the truth, this should have been brought up at trial. This is a defense to the charge of rape that should have been, because that's what they're doing. They're trying to say at trial they said it happened, but it was consensual. And so now that that's failed, now they're going to the appellate court and saying, well, we're sorry. What we really meant to say is it happened, but it wasn't actually rape. It was actually uh, outer course. It wasn't penetrative sex, it was outer course, and therefore doesn't meet the legal definition of rape. I'm guessing is where they're trying to go with this. Um, and I continue to say the this is something that should have been brought up at trial. This is a factual statement. One, I don't see how it helps Brock Turner even if he succeeds, but I doubt it can succeed because appellate judges really don't like you trying to bring up new facts on appeal that should have been that were known and should have been known at trial. If your client didn't tell you those prior to the trial, that's not the court. That is not an issue the court needs. Your client did not provide enough information for you to give him a vigorous defense. Sorry, you needed. Your client had his chance to defend himself, and he chose another tack. Um, Honestly, if you needed to go that route, you should have gone through it at trial. It should have been, look, it was consensual. It wasn't intended to be penetrative sex. That should have been two prongs of your defense. Because if you have a good defense has multiple prongs because that provides reasonable doubt. At that point, you can have multiple jury members who, if the jury isn't convinced by one prong, they might be convinced by another prong, or maybe different jury members will be convinced by different prongs, and then you can instill enough reasonable doubt that you can get out. So this clearly feels like, and I'm sure it's going to feel like to the judges, to the appellate judges, as a desperate attempt to retry the case, and get the most onerous part of the sentence removed or reduced, by retrying the case with something that should have happened at trial. So for those of you that are getting pissed off about this, please understand, this is actually probably not a very, this appeal is just kind of happening because they need to appeal it. You don't need to appeal it, but a lot of people seem to think that the appeal is a way to retry the case. I don't see it succeeding. Even if it succeeds, I'm not sure how this could ever help him. So I am, don't be too worried about this case. It's a cool case, admittedly. It's a bad case. It's a crap case. It's a interesting move from a legal perspective. And I think it's a completely stupid one. I realize I'm not a lawyer, and there might be a detail I've missed in here. Neither are the journalists who are passing this to us, and they're not really giving us a lot of information. The recaps I've read don't seem to be giving a lot of information about what is really being sought with the appeal. I guess maybe some of the earlier stuff, I might have been able to catch it when the appeal was filed, but I didn't catch that. So, given that, it seems like a really weird choice to me. Anyway, uh, I have been James Burkhart. This has been The Political Divide. Tell me what you think, and as always, keep talking.